guess there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all, 'cause you, my friends, are beautiful. We're gonna get you through it all the way.
Hi, I'm Shannan Mackey. For those of you who don't know me, I am an attorney here at the Law Office of Melissa Day. I started in October, and before that I worked for the special funds for since 2012, actually. With me here is Katrina Gray, and she's also an attorney here.
Yeah, and then before that I worked as a claimant's attorney for a while.
But then she joined the side of truth and justice. So today I'm going to be talking about prior medical records and using them to limit liability. We're going to talk a little bit about how to obtain them, even when people don't want to give them to you, and also what kind of things we can do with them and why it might be important to obtain them in certain cases. So to begin with, at the outside of the claim, you really want to obtain any information you can on a prior workers' compensation claims for numerous reasons that we're going to detail later. Also get an OC-110A and get that information as soon as possible so that you can use it as you go forward in the case. Also send a HIPAA to the claimant and start to gather the medical records. Really, the best defense is a good offense, and as I'm going to discuss a little bit later, when you are doing these medical record searches with prior accidents or with certain types of conditions, if you are able to not establish the claim due to that reason, it's the best outcome for not just obvious reasons, but also because you're going to face an uphill battle to use those medical records later on if you discover something else.
So you were saying to me that it was important to raise that early in the case.
Right. So when we get those records, and how do we get those records? The first thing is to send a HIPAA. If you're trying to figure out whether you should really pursue this or what's in there, you can look at the medicals specifically on your file. Look at the list of current medications. Sometimes there's medications on there that the claimant has already been taken, and if you see pain medications, skeletal muscle relaxants, if it's a back claim, skeletal muscle relaxants are typically used for back and neck and more spinal conditions rather than like your knee or your hip, so you can look to see what it is. The previous diagnoses will also be listed on a lot of those medical reports, and you should look at the ones that aren't there to see if any of them are progressive diseases or types of rheumatoid arthritis that could also be causing the disability. Look for the names of other providers. A lot of times the letters will say, "Dear so-and-so, thank you for the referral." That name is typically helpful because you know the claimant went and saw someone else for this condition, and if those reports aren't in there and that's not the initial thing, he was, it wasn't necessarily billed through comp. And look at the general list of symptoms. A lot of times the doctors will have the constitution of the claimant. They'll say, you know, general symptoms, orthopedic condition. One time there was an indication that the claimant was alleging he went out of work for a back, but he was using an aspen collar at the time he went out of work for his back, and it was just listed in small print in that little area. An aspen collar is a cervical collar, and it turned out he had surgery to his cervical spine just before he needed to go out of work for the back. You can also do a geographical search of providers. There's investigators who will do that, where they'll call different providers and see if the claimant has treated there. That's hit or miss because some of the providers won't answer. Do an ISO search if you have the ability. If you're still garnering that information and you're not sure, you can accept under 21A. And we can ask the claimant flat out during the initial hearing if they were currently treating for anything. You can ask if the claimant was treating for any type of condition currently that might cause the symptoms. Was he on any medications? And we'll talk about that later, but one of the claimants answered that way and then wouldn't provide those medicals, and the board indicated that in order to depose his treating doctor regarding those medicals, he needed to provide them to the board and he needed to provide them to the carrier, and until he did, they were not able to move forward. So you can also get those records in the cases of hesitant claimants. And Katrina, have you ever had a case where the claimant wouldn't sign the HIPAA and wouldn't tell you about previous conditions?
Yeah, actually recently we had a case where we actually asked for the unrestricted HIPAA at the pre-hearing conference, I believe, and we had an ISO report which indicated that there had been previous accidents, and the judge did not want to cooperate with us. What would you have done in that situation?
So in that situation, the claimants, even if they don't want to give an unlimited HIPAA, still have to give a HIPAA. There's a case matter of Syracuse, which is a little outdated because in the matter of Syracuse, and back in the day where 15.8 still existed, in the matter of Syracuse, the only reason you had to give to obtain prior medicals is that you wanted to see if there was a valid claim for 15.8, and for 15.8, every prior medical condition was fair game. So the board would essentially say, okay, you want an unlimited HIPAA, you get it, or that's what they were supposed to do, and the board panel decision from that. But the matter of Syracuse specifically notes that the carrier has a right to access the claimant's complete medical history, so the carrier may properly investigate the claim, develop any defenses, and explore issues, and then they go on to say such as 15.8. A survey of decisions, more recent decisions, and this comes from a more recent decision, indicates that now you need to actually have a reason you can articulate for why you want that HIPAA. You can't just say, oh, I want the HIPAA. And if you can clearly articulate that reason as to why the records are material and necessary before the board, they will direct the claimant to release medical records to the carrier. And if they're not doing that, you can go ahead and you don't have to continue to pay for it. I mean, the board would have to tell you you can't pay, you don't have to continue to pay for things. But I have successfully used this where we have stopped paying for both medical and indemnity because the claimant refused to sign any sort of HIPAA release with a basis. Some of the things you can use as reasons, listed diagnoses, listed medications, an employer witness indicating that there was a previous condition could help, surveillance reports, the ISO report, excessive sick time from work, if you have those records, or very recent sick time from work, all can provide a basis for an unlimited HIPAA. I have a case that I'm currently litigating where the claimant raised a cervical spine condition and he was off the 3 days prior to the work-related accident. It turns out that he had gone to the hospital and the chiropractor before that accident and had actually told them that he was out of work because of his cervical spine those 3 days prior. He told us it was the flu, but once we obtained the HIPAA from him, which he was slightly hesitant to give, and once we obtained those medical records, we were able to demonstrate that the claimant was out of work and the claimant had had problems prior to his work-related accident.
I have a case right now that I'm working on where the claimant actually retired quite a while ago, and they retired for different medical reasons, so that's going to come in handy for that too.
Right. And so there's some times when you need to do that or to use these, and one of the things that I think the board is terrible at dealing with is specifically progressive and disabling diseases. I say this because while at Special Funds, had a case that I sat in on, so I was not actually the attorney of record for the later case, but there was a 1994 accident and a 2017 accident. The 1994 accident had like a week of treatment, no lost time whatsoever. The 2017 accident, the claimant fell. He fell at work. It was admitted he fell. He had the fall. He had numbness in his foot, and he fell over his foot. He fully admitted he tripped over his own foot, and that he was having increasing neurological problems since that fall. The carrier did actually accept that claim. They didn't accept it per 21A, but they moved forward with it, and eventually that diagnosis ended up being ALS. So the reason the claimant's foot was numb, the reason he had the foot drop, the reason he was falling and had all of the disabilities related to specifically the ALS. I kept track of this case and recently looked it up. It went to the board panel decision, and the board panel, or after it was established, they went to a board panel decision for finding that the claimant was not entitled to awards or treatment on it. And the board panel basically said, too bad, so sad. That's the accident. The accident is from that fall. You accepted the fall, so you accepted the consequences on the fall. And the carrier is almost on the hook now for this claimant's ALS.
So if it had been raised earlier, it probably would have been resolved better?
I think so, and I'm going to discuss that a little bit on the next slide.
I'm sorry.
Go ahead. No, go ahead.
As far as a lot of the idiopathic injuries, I'm assuming that a lot of that could get resolved with the access to the unrestricted HIPAA.
I think so too. With the, I mean, in this case, it wouldn't have mattered because he wasn't hiding it. He just didn't know about the diagnosis until after the fall. He didn't go to the doctor until after the fall.
But a lot of the idiopathic injuries where there doesn't seem to be any explanation and someone just falls, you know, and it could be explained by something in their past.
Right, that they have a disease or these progressive diseases where they're not missing time from work necessarily in the beginning of it, but the thing with the progressive and disabling disease, it gets worse. You don't actually start off with the falls, with the numbness, with the pain. You're able to work, and you're not disabled in a compensation sense until you are. And so I've seen that happen with that case, and actually a couple of others. Doing research on it, though, I did look into rheumatoid arthritis, and rheumatoid arthritis was a condition where this came up frequently. And in my research, the board seems to disallow claims on the basis that the doctor could not say whether the rheumatoid arthritis or the injury or occupational disease caused the disability. But in these cases, the rheumatoid arthritis was raised on the outset. They were raised before the claim was established during the doctor's testimony. One case found that the doctors who didn't know the claimant had the diagnosis of rheumatoid arthritis were not credible. And the other doctors really couldn't say this was a hand and wrist, not carpal tunnel syndrome, but a hand and wrist claim. And the doctors couldn't say whether the rheumatoid arthritis or the hand and wrist was causing the disability. But in what seemed, and obviously I wasn't actually involved in these files, these were just the cases and the board panel decisions, but the board has actually continued payments and found no apportionment where the diagnosis of rheumatoid arthritis was pre-existing and the schedule loss of use came on the wrist and hand schedules for that rheumatoid arthritis. So if they didn't bring it up to disallow the claim, they got stuck paying for it as if the claimant didn't have rheumatoid arthritis to begin with. I also did some research on fibromyalgia and did find some cases where diagnoses and conditions were disallowed because of fibromyalgia, but at the same time, fibromyalgia I've never successfully used it to, or I've never even seen it successfully used to disallow medications or claims or payments, or not claims, payments after the case has been established. And I think going back to what you said, it has to do with the outset.
So even if you bring it up at the outset, even if it's not completely developed, it's there in the record.
Right, and you can bring it up in the in the outset. And this is just my thought on it. Before establishment, while Section 21 does apply, the burden of proof to demonstrate that the injury or occupational disease caused the disability is still with the claimant. So the question for an accident is, did the employment act upon the condition in such a manner as to cause a disability which had not previously existed? So like in this rheumatoid arthritis case, the claimant had pain in their hands, they were taking certain medications, they had range of motion restrictions, they had functional restrictions and limitations. So when the questions were asked to the doctor, you know, did it get worse even though there was an accident, a clear accident that happened, the doctors really couldn't answer, yes, it got worse, because it didn't. And the same thing with an aggravation of a pre-existing active and symptomatic condition is not an occupational disease. So in those cases, if they were trying to claim it was due to repetitive use as an occupational disease, it really, you're not supposed to be able to establish that type of case. But I've seen tons of these cases where they have been established for, even though these questions could not have been answered. And after establishment, using any of these factors to limit liability is very, very difficult. So I don't know if you've ever tried to raise involuntary retirement on someone, and that's typically very difficult, correct? Like, you have to demonstrate that the claimant really had that the injury or the disability as established, and you can't go back and say, well, he doesn't really have a back injury, he only, or a wrist injury, he only has rheumatoid arthritis, because it was established to the wrist. And at that point, you have to say that that wrist didn't play any role whatsoever in their retirement, which is a very difficult standard, because all they have to do is basically say, oh yeah, no, I would have kept working, and yeah, there were some other things, but it was totally this wrist injury that made me stop working, and no.
But then if you have the HIPAA, the unrestricted HIPAA, you have a lot more to bolster support for your position.
Right, and you can use that to try to discredit the claimant. But if you have nothing,
right,
then you can't use it. But the only thing you're going to really use to do that is that medical report. Absolutely. Unrelated apportionment or apportionment to a non-comp injury.
Yeah, that's interesting.
That standard disabling in a compensation sense, and I'll discuss that a little bit later. But it's a difficult standard to meet. Another thing that I've had happen, and I don't know if you've ever had this, but I've had cases where it's established and the claimant has invasive treatment such as surgeries, and they have an underlying condition rather than the surgery that is probably causing the disability, but now they've had surgery in the file. I don't know if you've ever...
Yeah, things like that have come up.
And I have one case where the claimant, the treating physician, asked for the surgery. The IME doctor said no way that this surgery will help them. They don't have any of the findings on MRI. They don't have any clinical findings that support this surgery, but the treating doctor said, no, let's do it, let's go ahead. And after the surgery, the claimant got no better whatsoever. They continued to have their symptoms progress and were diagnosed with a rheumatological condition, which may or may not explain the condition that they have. And what do you do with that? Because they had the surgery due to the injury. They had the surgery due to the established file. And that surgery undoubtedly made them somewhat worse, this unnecessary surgery. So how do you say they have no permanency in this file, even though it's now related to something else? So it's good to get that information early on to try to raise these issues. And so a lot of people do get it before treatment. You get the IME, you ask for these type of medicals. One of the other things I've seen a lot is medications. Have you ever had a case where the claimant is on a ton of medications, but it looks like those medications pre-existed the injury?
I've had cases where I wasn't sure, and we didn't have the unrestricted HIPAA at that point.
I've seen quite a few where the claimant has been, especially gabapentin or Lyrica, because as far as medical necessity, it's most of the doctors, most of the IMEs and the file reviews will indicate that gabapentin and Lyrica are medically appropriate and causally related for back pain or neck pain.
If I do see something like that in the file, I consider recommending that it's looked into, that through the unrestricted HIPAA access, because then we could possibly recommend the opioid weaning, etc.
Right, and it's the same thing with opioids where you have the claimants on it, but it's more difficult in my experience to get the claimant off the medication or to stop paying for it after you've been paying for it, especially if you've been paying for it for years, than it is to just stop it off the offset. But one of the tricks I've noticed is if you look at the initial prescription request, a lot of these medications are titrating medications. You wouldn't start someone at 300 milligrams daily of Lyrica. It's on Lyrica's website. Lyrica in their guidance says you start someone on 50 milligrams 3 times a day and then bump it up. Gabapentin, you start someone with one 300 milligram tablet, which is subtherapeutic, so it wouldn't even be something you would stay on, and then you bump it up 1 tablet every 3 to 5 days. If the doctor is starting the claimant on a 3,600 milligram dosage of gabapentin, you should really look in to see if that medication had already, the claimant had been on that medication for a really long time, and this is just a continuation of it. Same thing with opioid narcotics. I mean, if you see someone where the initial dosage is 70 milligrams or MED, that's probably not an appropriate dosage. With the prior narcotic use, sometimes the allergy section will list if they have allergies to it, and you can kind of tell then if they were on medications previously for that. And sometimes when they say allergies, they don't necessarily mean allergy in the sense that they had allergies. It could also be bad reactions. I've seen misuse and abuse essentially listed as an allergy in the allergy section. And you can check that to see if you should be allowing the prescription or the initial prescription of opioid narcotics to start. Again, going back to the obtaining the unrestricted HIPAA, getting these high dosage initial requests, this would be one of the reasons you could bring up to say why you need to obtain medical records and get an unrestricted HIPAA. Another time that it's really great to get these medical records and really look at them is before the awards start. I've had cases where the claimant was taken out of work and basically went to her work-related accident doctor the same in the same time period. I had a case where the claimant was taken out of work for schizophrenia and went immediately to her back doctor and said, my back really hurts, and got taken out of work for her back condition. The schizophrenia, she was taken out and she was never ever released back to work, so there was no basis to start the awards. We could bocce her on it, but just based on the medical in the file, it was...
You said bocce her?
Bocce, yeah, BACCI. It's a case where you can raise that if the claimant was voluntarily removed from the labor market, that they're not entitled to awards even if they become total, because eventually her doctor did put her at total. But that was how that condition went. The judge actually found her awards to be causally related, but we did win on appeal, which was a good file. I see this a lot with cancer files where the claimant is diagnosed with cancer. And there's always that question of which came first in time. Was he out because of the cancer, and was he out because of the back injury? And it's remarkable to me that no one is ever taken out of work due to their cancer. It's always due to their work-related injury and not due to the cancer. One of the things you can look for is if you obtain those records, seeing if the claimant was taken out of work for that when chemo actually started, or that there was or that other than the cancer, there was no change in the work-related condition. If the doctor's been saying 25% all along, and then all of a sudden the claimant is total, but his pain levels and his medication use and everything is exactly the same, that would be a time when I would definitely obtain that unrestricted HIPAA in order to go after that, and just ask for it. Ask the claimant before picking up awards if there's another condition that the claimant's actively treating for, or if there is any other reason he or she might have been taken out of work. And then if you get the truth, you can pursue it, and if you get a lie and you find out about it later, you can pursue fraud for that. Another thing we can do with this medication that we're all used to is apportionment. The types of pre-existing conditions for apportionment, I label them as 4. So the previous workers' compensation file, where there's no barriers to repayment, a previous workers' compensation file with barriers to repayment, a previous non-work accident, and a previous schedulable condition. And I kind of broke those off. We can raise these at different times, and we should raise these at different times. And the standards are all different for all 4 of these types of accidents. So a previous comp injury with no barriers to employment. If you get an early opinion on apportionment, you can try to set the date of apportionment early. While it's kind of gone out of vogue, at least when I first started, we would always seek, or other people would seek to set the date of apportionment as early as they possibly could, based on the date of their first medical. Now I see a lot more that people are setting the date of apportionment at permanency. If you are doing this and you are the one paying, you want to make awards per 25-1F, because there is a lot of flexibility when it comes to setting the date of apportionment, and the board does have a lot of discretion on where they set it. But this is something that the board has really been kind of allowing more recently. So when is apportionment ripe in a case between 2 workers' compensation claims? So when you were practicing a claimant's counsel and you had somebody raising apportionment previous, or when was it appropriate to litigate? Do you know when they push it for?
I know that it's recently been overturned.
Right, but it was always permanency, right? Like it was always ripe at permanency.
Well, now you can do it prior to permanency in certain situations.
Not just in certain situations, really. The board has Gowanda Central School District, which is a May 2015 and 2019 claim. So this is a month ago.
I thought it was just if it was 2 workers' comp claims, now you can do it.
Yes, it's 2 workers' comp claims. Okay, yes. And the board actually stated, because the issue of apportionment in this instance involves 2 workers' compensation claims, the board panel finds that the issue of apportionment may be addressed prior to a permanency finding. So the board is no longer, or the board is saying you can go ahead and move forward with this. The board has also, though, said, and it hasn't overturned this at all, that where there is medical evidence sufficient for the board to acknowledge the issue of apportionment between 2 workers' compensation claims, the awards should be made pursuant to 25-1F. So whether you want to pursue claims between 2 workers' compensation claims, or whether you want to just reserve your rights under 25-1F and seek apportionment later, is really a decision you have to make. The board does not have to allow you to seek permanent or to apportionment prior to permanency. In Gowanda, I could not tell from the board panel decision why they let them seek apportionment early, as opposed they made the awards per 25-1F while they were litigating apportionment, but I could not find a reason why it was appropriate or necessary to litigate the apportionment.
They didn't state it specifically.
Right, they didn't have any sort of rationale for it. But there are cases where there is a rationale, and those are ones where the previous comp injury has a barrier to payments. So barriers to payments, from what I'm talking about, are include just payments, barriers to indemnity payments. The earlier case is Section 123, or should be Section 123. The earlier case has a 114A finding. The earlier case has a large overpayment. You also have cases where it kind of is a barrier to both medical and indemnity when the case closed on a Section 32, or cases with third-party credits, especially large third-party credits. In these cases, you really want to get an opinion on apportionment as soon as possible, because 25-1F won't protect you. In order for 25-1F to protect you, there needs to be another carrier to reimburse you. The other carrier is not going to reimburse you for indemnity if if they have no obligation to ever pay indemnity under 114A or 123. Or if they have an overpayment, they're not going to necessarily pay you the money and rather than recouping their overpayment, although I have had that happen as well, where the carrier had to pay per their portion share and just increase their overpayment. You can raise this tentative apportionment as soon as awards, but they can't be under 25(1)(f), as there's no reimbursement. In these types of cases, typically I've tried to raise tentative apportionment, and I've done it quite often successfully, where you only pay the portion of what your doctor is opining is the tentative rate.
Oh, okay.
It's kind of like when you have a doctor opining a 50% disability and a doctor opining 80% disability. You pay the 50% rate, so there's no overpayment. You do the same thing with the apportionment and litigate it as you move on. Matter of Redzenberger is a 2018 case, and a lot of these cases where they're allowing the findings of apportionment prior to permanency are from 2018 and 2019, and that one is moving forward on it and saying that there's an issue of tentative apportionment that you can use so that the claimant, and that one it closed on a full and final 32. The claimant is essentially getting paid twice. And what can you get to do these? Obviously the OC-110A. You want to get that early, get those medical records early, because sometimes it takes the board a little bit of time to get you everything you need. I'm laughing because Najee is nodding his head as he gets a lot of our medical records. The HIPAA and medical records, oftentimes in these cases, especially the cases where there are no further payments, the board stops getting the medical records. The carrier stops getting the medical records. Some claimants will start putting everything through their private insurance when they no longer need to get paid indemnity. Some claimants will also stop putting everything through their private insurance when they're supposed to be paying it per their Medicare set-aside. I've seen that happen, or their third-party settlement. I've seen both of those happen. You can look for pleadings in a third-party action where the claimant says that, they were so disabled that they could never walk again because of this motor vehicle accident, and then, they were miraculously cured.
Miraculously.
And if there is an MSA, especially CMS approved, especially if it's a WAMO one, you need to provide that account. The claimant needs to provide an accounting to Medicare every year, and they're supposed to say exactly what their bills were and what they were for. And Medicare requires that, and with the WAMO files, and I used to do the WAMO files, we actually used to ask people, you understand you need to do this at the hearing. So either they're going to have those records showing that they've been paying for the Medicare, or they're going to have a lot of money in a separate interest-bearing account that's available to use for this care that you're now paying for, so you can, point that out to the judge. Or they're trying to defraud Medicare because they said they were going to do that and they didn't. They used it to buy a boat. So you can use all of those. I think every single one of those factors of possibilities helps you in saying that the claimant should be more responsible for payment on their care, and there should be a tentative rate, because he's either not trustworthy, or they've been treating all along for this injury, or they have a ton of money to use to treat for this injury, or not a ton, but money to use to treat for this injury.
Allocated for it, yeah.
Right. And you can get usually the 32, or if you contact the carrier or someone else, especially on the closed files, you can try to get the copy of what exactly the Medicare set aside, even if it wasn't CMS approved, was based on, if it was based on anything, obviously.
And you could ask for a direction that the receipts be produced.
Right, you can ask for a direction that the receipts are produced. You can ask for a direction that the claimant produce the information they have on the Medicare set aside. Any of those types of information would be helpful in these cases and would allow you to further pursue that. And there's also the case of a previous non-comp injury that would have resulted in a schedule. These, again, you really want to get those medical records right away, as soon as you know about your accident, because you need to be specific. The board has indicated it should not be based on speculation, and records can disappear, and records can take a long time to get. So if you wait until there's an opinion of permanency and you have 90 days to get an IME, take the depositions, and have a decision made, you're not going to necessarily get those medical records that demonstrate the claimant had, had no range of motion of his shoulder before the injury anyway. So you won't get to take credit for that schedule. You don't need to actually obtain the opinion on the apportionment or what the schedule would have been until closer to permanency, but you do want to have those records kind of ready to go for when they're needed. I mean, have you had a case where that's kind of been a scenario?
Well, I'm thinking of a case that I just did work on. I did a lot of depositions of the doctors, and within a lot of the records there was an indication that the claimant had previous, I believe it was lumbar stenosis, and we were able to, within the depositions, get the doctors to concede that it could have been pre-existing, and actually I believe it was, this was a controverted case. It hadn't been established yet, and I believe at the pre-hearing conference I raised, I'm trying to remember if it was I raised it at the, no, I think I raised it in a memorandum of law that we felt that the claimant was being fraudulent because there was some mention of back treatment. And ultimately, it went forward. Depositions were taken. We did memorandum of law, and we just got a board panel decision back that the case was disallowed. So we're happy about that.
Right, and that's a perfect example of using it before it gets established, to kind of just throw a little bit of shade on the credibility of the
credibility was key, yeah,
of the claimant, and that's what kind of allows it to be disallowed. And it's much more difficult when you go on to a previous non-comp injury or that stenosis, regarding whether the claimant had a previous condition that wasn't disabling in a compensation sense or credibility.
Because I find also a lot of the times it's the doctors, even though they're not going to say something that's not true, it's their natural inclination to want to protect their patients, so maybe they want to see it in a certain light. I mean, I suppose that's just an opinion on my part, but the way I read it, sometimes they could phrase things a variety of different ways without being untruthful, and sometimes it seems to favor what would benefit the claimant.
That's Michael Baden. He's the expert witness in the O.J. Simpson trial, and he wrote a book, and his big quote from the beginning of it, and paraphrasing, is that expert witnesses hide behind the language of their expertise in order to confuse and obscure the truth. And that's absolutely true. And it's this same case with previous non-comp injuries. Standard is disabling in a compensation sense, or whether the claimant was active and symptomatic is something you can try to show. And I don't know if anyone's ever had somebody who had a 3-level fusion and is all better because it was not a comp injury, but they had a small little tweak in their back, and they can never work again because of that small little tweak that did not result in a future surgery. It's really, it's like
it's kind of amazing.
It's very, this is the quote from Monty Python, where she turned me into a noob, but I got better.
Yeah.
So, yes. And there's other things you can do with the previous files just by getting an OC 110A. The board's really pushing the full body permanency, no schedule for cases where there is pending classification, taking credit for previous schedules to the same body part, even if the injury sites are different, or a full body classification even when all of the claimant's injury sites are schedules. And that's, why I have a picture of the Black Knight. He's obviously not going to be classified because, as he notes, it's just a scratch.
Just a flesh wound.
He can still work. He would be the first one to testify he could still work. But those schedules would be a lot. So. And you can also use it for ongoing monitoring of the file, continue to get the HIPAAs, to continue to get medical records. While subsequent conditions will usually not rely, you have established liability for claimants who are not classified when they're released to work but not working due to unrelated conditions. I've had this before too, where people are using a lot of opioid narcotics or a lot of chiropractic care, but only billing a portion of it through comp. So in the aggregate, they're getting a lot. And I've had that where I've also done it with the apportionment of ongoing medication use for gabapentin or Lyrica, or of ongoing treatment. And so that was my presentation. If you liked it, I'm Shannan Mackey. If you didn't, I'm Brian Prince. And so I don't know if anyone has any questions.
So Leah Zakari asks if the ALS claim was with American Axle?
I don't recall who the carrier actually was, but it may have been. I was with Special Funds on the 1994 claim, so I was more kind of just chilling on it. I kept track of the WCB number, but I never paid attention to employers at Special Funds.
Rachel Egan wants to know again the case law for the non-causally related injury or disease when you don't have to pay the benefits.
Non-causally related.
She says she thinks it was Poshi or something.
Bocce?
Bocce. Oh, Bacci. I don't remember what the end of it is. If she wants, as long as I'm sure we have her email, I can email her the full site. But basically, it's just a case where the person went out of work for unrelated reasons and then became totally disabled,
Because of surgery, I think, right?
because of surgery, and they wanted the payments to be picked back up, but they weren't working. They didn't have payment. They didn't lose money because of that surgery. They lost nothing because of that surgery. So
Right.
they didn't get paid.
And the Bocce case is quoted all the time, I believe.
Yes.
Cited all the time.
Oh, bye. So thank you, everyone. And if you have any questions, you can feel free to email.
Don't go crazy. Things keep changing, and never for the best, at least not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day. When things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all the way. It's never easy, it's never fair. You can't find any reason anywhere. And if you're ever at your wit's end, we are here for you, our friends. Don't go crazy when the judge says your claimant had a good day. When things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all, 'cause you, my friend,